All right, we are here live again with Doug Rohan of Rohan Law. Doug, thank you for hanging out today. How you doing?
I'm doing great. Getting ready for spring break. I get next week off, heading down to Florida. Going to catch the Louisville FSU baseball series this
Heck yeah.
weekend. So this is really my last official act before I dip out of the office tomorrow.
Putting you to work on your last day. Um, last night we got a filing from FSU. We're going to talk about that a little bit and what it means. Let's catch up though as a quick refresher on what exactly is going on and why we're here today.
Yep. So we had the North Carolina hearing last Friday on the North Carolina filings. We've got a hearing coming up in Leon County on the 9th, next Tuesday. And so this is the last opportunity for the parties to get in their words before we get ready for I guess that's 2 Tuesdays from now because of my spring break. The 9th of April, we'll be addressing all of these pleadings in Florida. Now, there are some minor distinctions between the two, but basically it's the same thing: complaint, answer, motion to stay, motion dismiss. What we're talking about here today is FSU's response to the ACC's motion to stay the discovery proceedings in Florida.
A couple of guys put out some pretty good stuff on it. Matt Baker, Chris Nee, Irish Shellfell all put out articles. Um, what's your big takeaways from the filing on this?
Well, first, big shout out to Matt Baker, who was able to send me the documents so I could actually review them and look through them. I like what the articles are putting out there, but I want to make sure that as I'm coming on, that I'm talking from the source materials. And of course, I agree with a lot of what they had to say. I disagree with some of it. A big hay was made out of the fact that FSU was kind of pivoting and showing that they are in fact leaving. I'm not sure that's exactly the tenor of the language. It really has more to do with where we are in the proceedings today. And it's very clear FSU wants out and is looking to get out. There is some indication that perhaps the parties have talked behind closed doors. And at this point, the ACC has probably telegraphed that there is no chance of any reconciliation. So that's really what more of that tone or tenor is that the other articles were talking about when they say FSU is presuming that they're out. I think everybody has already presumed that FSU is out of the ACC. Yeah. So again, what we're talking about here is the ACC wants to put off discovery in Florida, and the Florida State is explaining in this really good brief. I think really this is the best writing that the FSU team has put together since the start of this litigation. But they use this as an opportunity to really hit hard against the ACC, what they're alleging, and explaining why providing these documents is so critical, because the ACC has repeatedly been caught in exaggerations. And so FSU is outlining those exaggerations and saying this is why we need the source material. FSU was able to slip in some great language as to the actual merits of the case itself. So FSU is really creative in how they use this response to a motion to stay discovery to really attack the entire lawsuit, including the inclusion of some of the Clemson language from their recent complaint.
There's a heavy emphasis on the procedure and the filed first status with this.
Yeah. So what they're talking about first is the issue that filing first again is not necessarily the end all be all of determining where this litigation is going to be heard. And we heard that echoed by Judge Bledsoe in the North Carolina hearing last week as well. But the bigger issue is that in trying to file first, FSU exposed itself to several exaggerations as to why it was filing first. They alleged that they had to go down there to protect their interests and also to protect ESPN's interests. And so that's what this filing is really getting into, the nitty gritty of why that's not the case and why we need to see the entirety of the ESPN agreement and the grant of rights to validate some of the allegations that the ACC is making.
All right, FSU threw an absolute haymaker that we're going to talk about later. But first, let's build like FSU did and get into the meat of this filing.
The first part they were talking about is the taking. So in their motion, FSU is talking about what is the actual taking, and they use that as a substantive basis to argue why this should be in Florida. So again, here we're just talking about discovery, but here's the first example of them inserting the actual controversy in a simple filing like they made here. So the taking is the taking of FSU's property broadcast rights from their home games from an institution that is located in Florida. So they use these 2 points to again reemphasize why this needs to be a Florida case.
All right. The next major part was the mischief. Let's talk about that just a little bit.
So this is great. This is where it starts getting fun. Again, what's entertaining in litigation is when you get to point out some exaggerations or some misstatements by the other side. So here, FSU is using that to bolster their argument of why they need these documents. So they lay out how the ACC is being mischievous in their assertions to the court. Discovery is all about sharing information, sharing the actual documents, sharing the language. So here, the FSU is pointing out specific and concrete examples of why the ACC can't be trusted to tell the court and to tell FSU what's in those documents.
So the taking, the mischief, and then we get to actually, before we do that, what are some of the examples that FSU points out in them stretching the truth?
So the first thing that they point to is specifically in the ESPN agreement about the commercially reasonable efforts clause. So what this is a statement within the ESPN contract that ACC signed saying, look, you are obligated, ACC, to protect ESPN's interests. So the ACC, when they filed their complaint, alleged, look, we don't have to take a vote of the members because we're just doing what the ESPN has asked us to do, and that's to protect their interests and to protect their grant of rights. The judge actually sent an email in North Carolina, Judge Bledsoe, to the parties asking for the definition of commercially reasonable efforts because that was something that was being litigated. Well, Kumi and the ACC attorneys provided that response, and it outlined what is commercially reasonable and what efforts are to be made. But the second part of that said nothing that would require you to lay out significant financial expenses, retaining attorneys, for example, litigating one of your member institutions departing. So it was very clear from the language of the reasonably commercial efforts clause that it wasn't outlining this type of litigation. So this is the first example of the ACC saying we had to do this, and yet the documents say exactly the opposite. What they're intending there in that agreement is if somebody starts rebroadcasting an ESPN game, you have to issue a cease and desist letter, something that's a standard 15-minute letter that would take to generate. So that's the type of commercially reasonable efforts that the ACC is obligated to undertake to protect ESPN, not suing one of your members and opening yourself up into the risk of losing hundreds of millions of dollars.
They do it to us on YouTube all the time. If we use their highlights too much or don't accredit things properly, yeah, they're all over it. So, were there other examples that the FSU brief tackled?
Yeah, so the second thing that FSU addresses is this idea of an injury in fact. And another matter that came up with some substance in the North Carolina suit was whether or not at the time of the ACC initial complaint, there was in fact any type of harm. And so what they're discussing here is the situation where the ACC anticipated a breach. They anticipated Florida State trying to get out of the grant of rights and out of the ACC contract, that it was clear of the intention of the Board of Trustees and of FSU, but it's very clear also in the law that an intention to breach is not an actual breach. So here the ACC in their unprovoked complaint, as the brief repeatedly cited to for FSU, this unprovoked complaint came before there was actual harm done to the ACC. So this is again showing the judge in Florida why ACC attorneys cannot be trusted to explain what is happening in the law.
What about the part of the brief where FSU brings up Commissioner Phillips and the unilateral extensions given to ESPN? Is this another example of the ACC just stretching that language?
Exactly. So the the Constitution, the bylaws say that the ACC has to get member approval for any changes to the material media rights. So the FSU brief cites this exact example of Commissioner Phillips going rogue and extending ESPN's contracts unilaterally without taking any votes of the members to show this is an argument as to why the ACC doesn't always say what the documents are describing. The ACC thought, the ACC presumed that extending these contracts with ESPN was not a material media right. But now that we have the documents, now that we're seeing the actual contracts, or at least portions of the contracts, the title of those agreements was Amendment to Amend and Restate Multimedia Agreements between ESPN and the ACC. How can you not say that is a material media agreement? So clearly, these two ESPN extensions were in fact material media rights, and they did so without getting the votes of the members. So here again is the FSU using a simple motion about discovery to stab the ACC about the actual issues and controversy and point out where those failings occurred.
Okay, so that leads us to discuss the ESPN agreement and this issue of confidentiality. Is this another example that FSU points to the ACC stretching the truth? We're just going to say lying at this point, but stretching the truth.
So the discovery that FSU is seeking is the actual written ESPN agreement. And this came up very clearly in the North Carolina lawsuit as well, where the ACC was arguing there was a breach of confidentiality because the ACC had informed its members that if we show you this agreement, you're not allowed to talk about the agreement because we have confidentiality with ESPN. And this is where Judge Bledsoe jumped in and jumped down the throat of the ACC attorneys when he included the last 10 words of that clause saying, subject to the laws of the states where the member institutions are located. So this is another example of the ACC saying, we're not allowed to disclose it, and we told you you're not allowed to disclose it. And the FSU is pointing out to the judge, if it doesn't violate Florida law. So here's a very clear example where they are explaining to the judge, you just cannot trust the ACC positions.
So I feel like this has all been building up towards this crescendo of accusations. We are going to get to our grand finale in just a moment, but I'll switch it up. I'll throw you a curveball. Tell us about Rohan Law real quick, and then we'll talk about the most exciting, the best part of everything that came out of this.
For your listeners, I didn't tell you to do that. I greatly appreciate
No. It's on me.
Here at Rohan Law in Atlanta, Georgia, we work primarily on protecting the rights of our clients who have been arrested or who have been hurt at work. And Atlanta Seminole Club is one of the largest Seminole clubs outside of the state of Florida. So we know there's lots of noles here in Atlanta and all of Georgia that are listening. So we want to make sure if you find yourself in a situation where you or a loved one has a need for an attorney in Georgia, that you know that there's a strong nole that's going to come alongside them to be with them on their worst day. We want to be your best friends on your worst day.
No, Doug definitely didn't tell me to do that. I just thought that we've certainly used you enough here that we need to give you some love as well. Make sure you're following Rohan Law on Twitter. Hey, somebody said something a few videos ago in the comments about buying Doug a beer in Ireland. We're gonna, before Doug comes on the next time, we're gonna find a way to set that up. Maybe like through PayPal or something. So, all right, give us the good stuff. Not that this all hasn't been good, but give us the grand finale of the accusations here.
Well, I'll be at Dick Hauser on Friday night, so look for me up in the animals, and I certainly will take all the beers that are bought for me.
All those legacy lagers.
Exactly. But yeah, so as I said earlier in some of the other tweets and videos, I did not get too heavy into the Clemson complaint because I did not have the bandwidth to add a second lawsuit to my abilities to actually do real work for my clients and to be a real father and husband to my kids, especially as we get towards the end of the year. But this Clemson complaint was attached as Exhibit F to FSU's motion. So it was really the first opportunity for me to start digging into it. And there are some of the things that FSU is adopting. Now, I did see some publications talk about this pivot in the language and this pivot in the arguments that the grant of rights only applied while Clemson was in the ACC. And I dug a little bit deeper into what specifically they were saying. And they did a great job of wrapping this up into a nice, neat bow. This is a way that everybody can really understand what's being argued here. But the ACC grant of rights irrevocably means it can't be terminated, owns the media rights to any games played through 2036, even if the member ceases to be a member of the conference. Now, what I love about law is it gets us to think about these statements in a little bit different ways to kind of twist them and to try and tease out what they're actually intending. And Clemson attorneys did a great job. Yes, it is true the ACC irrevocably owns all of those media rights, but for games that have been played through 2036. So as long as it's a conference game played by a member in the ACC on ESPN, the ACC owns the right to continue to broadcast that game over and over in the instant classics, in a look back, maybe in some conglomeration of a national championship run. That's the irrevocable nature. The media right deal does not extend to games after the member leaves the conference. And that's an important distinction, and one that initially I scoffed at, but now that I look at it a little bit closer, I understand what they're saying. Let's use, for example, what happens if a member is voted out of the conference. Let's say everybody is pissed off at FSU. We don't defeat the grant of rights, but all the members vote FSU off the island anyway. Are you telling me that you want to interpret this agreement to say if we're forced out of the conference, the ACC still gets to keep all of FSU media rights to 2036? That is a laughable interpretation. It's a great way to look at this matter, and I think lends substantial credence to Clemson's argument that their interpretation is correct. The ACC has an irrevocable right to any games that were played in the ACC by the member institutions. You can't tell me I have to get lost and then still get to keep all of my media rights through 2036.
Yeah, we talked about that. I don't know if you remember every single video we've done on it, but I actually went back and found it, and we talked about that like in June, I think, of last year, how the grant of rights only apply. And shout out Regal Noel, who does a really good job over on the War Chant message board. He talked about that. And we talked about like this scenario. We painted a picture of, well, could you go to the Big Ten with just half of your rights, because we knew that the grant of rights only applied to your home games. And so your away rights mean a lot, and playing Florida State and Ohio State in the shoe would be pretty massive. Now you'd piss off your local donors and people who have season tickets if you just played all the crappy teams at home, right? Like that's not really realistic, but it seemed like there was a path there. And Florida State, like you just mentioned, took it a step farther. I even talked about that on a video I put out this morning. Florida State took it a step farther to say like, hey, no. Once we're gone, like you don't own any of those rights. Like it is done. And at that point, my thought or my interpretation would be, hey, at that point, do you just pay the exit fee and go? Like, we're not going to owe money on top of all of this other, this $571 million, what these rights are worth, like the ACC certainly wants. And obviously that's for the judge and everyone else to determine if it gets that far. But to me, it felt like, well, if that's the case, and Florida State's right on that, they are negotiating from a much stronger position than even we maybe assumed 3 days ago before we got this filing.
Remember, the FSU and Clemson complaints aren't giving up on just the exit fee. They're not acquiescing to that $120, $140 million being a guarantee. They're even still addressing whether or not that is an excess. Clemson did a good job of talking about it, because when they signed the deal in 2012 and it was used as a multiplier 3 times the ACC budget, that was relatively nominal at $40,000 or $40 million or whatever that figure was that the Clemson cited in their suit. But now, because the budget has continued to expand and explode, that's why this number is so much more unreasonable than it was, especially in comparison to the other conference departure fees. So FSU is not saying, well, we'll pay the 120 and just get out, though I believe they'd take that deal if it was offered today. But if this litigation pursues, they're going to be exerting pressure on that number to come even further down.
Yeah, I agree. I think they would take the 120. Like the number I've heard tossed around is 150 is where Florida State would end up saying, oh, okay, we'll do this. Like, let's just get done, because the legal fees that they're paying certainly aren't cheap either. But yeah, I think if you could, and we talked about that on the channel too. The exit fee is exorbitant, and the board of trustees has brought that up and compared it to what the Big 12s is, what the SECs is, what the Big 10s is. Obviously, why would you leave either of those last two? But yeah, if you could get out for just the exit fee or less than the exit fee, if you could bump that down to 80 or 100, I think you'd be pretty thrilled. But man, exciting stuff. What's next for us, Doug? Where are we headed? Catch us up, and we'll wrap this up and get out of here.
So it's pretty typical for judges to not accept filings inside of 10 days of a hearing. So I don't think that we're going to see anything else. Perhaps the ACC tries to slip something in today or tomorrow before the close of business. But with the hearing on April 9th, I think this is probably everything we're going to see in Leon County. I know this might be a disappointment to some. I will not be in the courthouse on April 9th the way I was for the North Carolina hearing, but that's fine. There are more than enough local FSU attorneys and people that can cover the Leon County hearing. So I'm going to defer to their expertise while I keep getting some work done up here in Atlanta. But for right now, I will be happy to join you if I can get a strong enough signal once we get the judge's order from Judge Bledsoe in North Carolina. At this point, I would suspect that's probably coming Thursday of next week. It's important enough that they don't want to wait necessarily till Friday. So I'm going to try and make sure my Thursday evening is free, and perhaps we'll hop on with you earlier if we get that order. But I would keep my eyes out and my finger on the refresh button for some news probably Thursday.
Awesome. Doug, I appreciate you a ton for hanging out. Enjoy Tallahassee this weekend. I'm going up next weekend, so have a lot of fun. Have a great Easter, a good Friday, and thank you so much for your time and hanging out with us always, bud.
You guys are welcome, and go Noles.